How old are you?
37.
26.
51,
40.
31.
49,
29.
45.
Well, at this age, no.
Do I need to? Not yet.
No.
What would happen to your property if you don't have a will?
कभी ये सोचा भी नहीं है कि कुछ होगा करके.
अभी सोचा नहीं मैंने ऐसा होना तो.
Is it so important?
But I have thought about it.
It's really important, but I just don't know how to make it.
For most of my financial assets, I have a nominee, but I don't have a will.
Do you have a will?
Yeah, of course.
Have you registered your will?
You're not required to register your will. Why would I need a will? मेरे पास तो property नहीं है.
Do you have a salary account?
Yes.
That means you have assets.
Yes.
हाँ, गाड़ी है.
Welcome to the second part of Wills Made Simple. We continue our conversation with Karishma Choksi, our will expert in the studio. In the first part, we spoke about why is it important to have a will. And today Karishma will tell us what all should a will include, how to structure a will, what is the format, and what are the common mistakes to avoid while writing a will. Karishma, let's start with what most people want to know. What all does a will include?
So to make a will a legally binding document, there are certain elements that you have to include in your will. One thing is that you have to mention that this one is your last will, and all other wills that you may have previously written are no longer in effect. You must mention that you are of sound mind and you have written that will without any force. You must mention what assets you want to pass on in the will. You must mention the proportion and the beneficiaries who will get those assets. You must also mention who will be the executor of the will, because without an executor, the court will have to appoint an executor. You will also need to sign the will and get two witnesses to sign the will. You need to sign every page, and also it is prudent to have page numbers in the will.
Karishma, who is an executor?
Simply put, an executor is a person who will be responsible for passing on the assets as per the wishes mentioned in the will. But it is important to know that an executor will have to be able to manage all the administrative tasks. So it may be applying for a probate if required, talking to financial institutions, liaising with corporate housing societies in order to pass on the assets to the legal heirs as mentioned in the will.
So who is an ideal executor?
So you can appoint anyone that you trust and somebody who is in a position to manage all these administrative tasks. You could also appoint one of the beneficiaries that you've mentioned in the will as an executor. So if you say passed on the assets to one of your children or to your spouse, if they are in a position to manage these administrative tasks, then you can even appoint them as an executor.
Karishma, tell us, who is a beneficiary?
Beneficiary is anyone who is receiving any asset under the will. Anybody can be a beneficiary. You can have your family members, you can have a friend, you can have a charitable organization as a beneficiary. So anyone who is receiving anything under the will is a beneficiary.
Okay, you also mentioned the word probate. So what is a probate?
A probate is nothing but a stamp by the court on the will, which gives the executor of the will the power to then go ahead and distribute the assets. So a probate may not be compulsory in every city. It is compulsory only in certain presidency towns, and the probate process happens only after the person is no more, when the assets need to get distributed, because very often there are people who get confused in whether, if my will is registered, do I need a probate? But there are two mutually exclusive things. Registration happens when the person is alive and you're registering the will with the registrar's office to prove its genuineness, whereas a probate happens after the person is no more. A probate is generally filed by the executor in the court, and the court will then give him or her the permission to go ahead and distribute the assets.
So are you saying if one registers their will, they don't need a probate?
No. Registration is completely different from a probate. Registration is not mandatory. You can choose to register it or not. That will only help to prove the genuineness of the will if the will gets contested. The probate happens after the person is no more, wherein the court is giving the permission to the executor to go ahead and distribute the estate. So registration and probate are both mutually exclusive. One does not depend on the other.
Okay, tell us, who can be a witness?
Anyone who is above the age of 18 and of sound mind can be a witness as long as they are not receiving anything under the will. So you cannot appoint a beneficiary as a witness. Also, any close relative of a beneficiary cannot be a witness in the will. And also it would be prudent to appoint somebody who is a lot younger than you to be as a witness, because the witness's part comes in if the will gets contested. The court may call upon the witness to come and testify that they had actually seen this person sign the will. So always appoint somebody who is a lot younger than you. Just to give you an example, say my daughter is one of the beneficiaries in the will, then my daughter cannot be a witness and nor can her spouse be a witness in the will.
We often hear that all our accounts have a nominee. Then why do we need a will if we have nominees in all our accounts?
Yeah, that is a myth that a lot of people have, that if I have a nominee, then why do I need a will? But a nominee is only holding the asset in trust for the actual beneficiary or the legal heir. A nominee does not have a legal right on those assets. So for example, if my son is named the nominee on my bank account, but in my will I say that the proceeds of that bank account have to go to my daughter, then my daughter actually has the right over those assets. There is only one exception to that rule, which is in the case of insurance policies now, where insurance policies have got a beneficial nominee named. And only in those cases, the beneficial nominee will override the will. But in all other assets, whether it is bank accounts, fixed deposits, mutual funds, demat accounts, or even your flat in a cooperative housing society, the nominee is only holding it in trust for the legal heir. So the nominee is not the legal owner.
Karishma, we've got some interesting questions from the audience. Let's have a look.
So while I don't have a will, I have a gift deed from my mother, and I would really like to know how they are different.
A gift deed is a document that comes into effect during your lifetime, where you gift your assets to somebody during your life. Whereas in a will, you pass on assets after you are no more.
So you're saying that anything that one has gifted does not need to be part of the will?
Yes, because the ownership is already gone to the other person during your lifetime. So you cannot pass that asset on in your will because you don't own it anymore.
Okay, yeah, makes sense. Let's take the next question.
I know I don't have a will, but that is one question that I would want to ask. Is oral or verbal will valid legally?
Verbal or oral wills are not legally valid. You must write the will, you must sign it and get two witnesses to sign it for it to be a legally valid document. Oral or verbal wills are allowed in very, very special circumstances, like if there is a soldier on the battlefield, but for regular civilians, oral wills are not allowed.
So Karishma, we've come a full circle now. In the first part, we spoke about how everybody is always busy accumulating a lot of wealth and assets. But we most often than not forget that we have to also think about how will all these assets get passed on to our loved ones. I hope we've been able to drive the importance of writing a will. And as Karishma said earlier, it's not only necessary to make a will, but also very simple. Thank you, Karishma, so much for joining us today.
Thanks so much, Aditi.
Feel free to reach out to Karishma. Her details are on the screen.